Hi, this is Jim Cunningham, and today we're going to talk about estate planning for life partners and unmarried couples. This is a live webinar that we're recording and will be up on YouTube. So something very important to understand, I'm a lawyer, I'm talking, this is not legal advice, okay? Don't watch this and say, well, Jim said, and go out and do a bunch of stuff, because that's a really bad idea. If you're watching this on YouTube, go ahead and subscribe to our YouTube, and you can click the bell and you're alerted when we post a new video. These are posted pretty much every Thursday. Sometimes we take a break if there's 5 Thursdays in a month. And we have offices in Northern and Southern California. You can see the Golden Gate Bridge and the Southern California shot as well. These are our current lawyers at Cunningham Legal. All we do is estate planning, trust, and probate law and tax planning, right? So very important. I'm the CEO and partner at Cunningham Legal. I've got over 25 years experience. We help clients in other states. I'm a certified specialist in estate planning, trust and probate law, as well as securities and insurance licensed, and a pilot. So and a real estate broker. So a little bit of a certificate junkie, I guess you could say. Second edition of the book is out. I really encourage you to take a look at that. You can go to our website and look at our book. And let's talk about estate planning for life partners and unmarried couples. So these are for people who are living as if they're married, okay, but not. And they're living in a committed relationship and just haven't kind of taken that next step to getting married. And this, I would say, probably, you know, there's no simple area of the law. I would say there are more or less complex areas. This is probably one of the most complex areas in estate planning. Lots of benefits to being married. It doesn't mean if you're not married, you can't do planning, but sometimes that planning is a little more constrained, a little more restrictive, less freedom, less flexibility, if you will. But you know, the reason you're watching this is, you know, this might be you, this might be somebody that you care about, might be a child, a parent, or something. What we're talking about is people who are in long-term relationships, and these are called non-traditional couples. I think that we've kind of moved off that. You know, we're including that because people, I think, still use that as a legacy term. What we're hearing now more is life partner. That's kind of the term that's used. And the whole reason of watching this is making sure that if you care about this person that you created a life with, you want them to benefit from your estate. And you want to avoid a complicated estate administration process. Certainly want to avoid litigation. That means going to court and hiring a lawyer, lots of money. And you want to reduce taxes after you pass away, and all across the board taxes. And there, I would say that not all estate planning attorneys understand this. Very few attorneys understand sort of the spectrum of nuance in the law on this. But so we're going to cover life partners. And I would say, these are people who are living as if they're married, but they're not. And why don't people get married? Well, I will tell you, one of the most common reasons that people do not get married is because of one of these people in this committed relationship is married to somebody else, okay? And they might have just been estranged or split up. You got to deal with that, all right? Because being married, cohabitating with somebody else, you're going to see as we go through the materials, it's really kind of a minefield and really ripe for litigation, if you will. So it's very important to pay attention to that if that's you. And the other reason people don't marry is many people, if they remarry, they might lose some retirement benefits. They might get a haircut on Social Security benefits. So there's some public benefit issues there that do come up frequently with clients. And then I think probably again, another reason people don't get married is they say, look, I've had 3 failed marriages. I've been with this person for 20 years. I'm afraid if I actually marry this person, you know, I'm going to end up divorced. So I would say that there's another whole thing of registered domestic partner in California that is interchangeable with the term spouse for state purposes, meaning you file a joint state income tax return in California and you can transfer real estate freely between each other and not get reassessed. So that's a big issue for a lot of our clients, is preserving Prop 13. And what is a couple? I mean, let's just kind of take this broader view. What if it's a child caring for an aging parent? What if it's a parent caring for a child? In many senses, those financial and personal lives have been heavily mixed and blended. So they kind of look like a couple in the sense that, you know, if you have a parent who's got a child with special needs, that parent may want to provide specifically for that child to the exclusion of other children. Sometimes not. But you see where I'm going with that. We're not going to really cover that, but I did want to mention that because if you're caring for an elder, you kind of this might resonate as we go through the materials. So this is really important. We have some marriage rules in the United States. You can only marry one person at a time. Well, actually, you can marry additional people, but if you marry more than one person, that is called a bigamous marriage, which is essentially a fake marriage. It is not recognized by the law. This pulls the sort of putative spouse doctrine. So if you're the person who has been estranged from your spouse, and then you marry another spouse, or you're kind of married at the same time, the bad news is, if I go out and marry a woman and marry another woman, and they all find out about that and they all want a divorce, each spouse gets half, I get zero. Okay. So the spouse, the bigamous spouse gets no property. So that's very important to understand. That's called the putative spouse, and the law protects them. So there are 5 big rock issues. And I like to say, if you've ever heard this talk where big rocks, little rocks, let's talk with the big rocks, and then you put the little rocks in, you fill the sand, and that's kind of how you can you attack this. There are 5 issues, 5 big issues for unmarried couples that I do want to cover. One is just decision making in general. This is who gets to decide. So if you have a couple and one spouse or one life partner becomes incapacitated, who makes decisions? Who decides stuff? Well, only a person who's empowered to make decisions has the authority to make them. Now, what do I mean by someone empowered to make the decision? Well, you make your decisions for yourself while you're certainly, fully functioning adult. You go out into the world, you make decisions every day. But when you become incapacitated, you lose the legal capacity to make those decisions. And these are decisions in 3 big areas. One is healthcare decision making. So if I'm got tubes coming out of my nose and everything, and I'm in the hospital, I can't make healthcare decisions for myself. Someone else is going to make those. Now, I happen to be married. That would be my wife. A spouse has effectively a statutory first place. So a spouse makes decisions for the other spouse. If you are life partners and not married, that is as close of a relationship as it is from me to you. And I don't know, I might know some of you on here, but understand that the fact that you've been together for many years and have a history of being together does not give you any sort of statutory authority like a marriage would, or a blood relationship would. Personal decisions, where do you live? Who do you associate with? Voting and all this other stuff. Financial decision-making, okay? Financial decision-making is who takes care of the money. So on the one hand, who takes care of the person, and then who decides all these sort of miscellaneous issues. And then the financial decision-making, again, you have the power to appoint somebody, but too often it doesn't happen. So what happens if you don't have an advanced healthcare directive? Now, this is also known as a medical proxy or a living will or a lot of other terms, but we're just going to use the term that California uses, which is advanced healthcare directive. Sometimes people put in a D there, so it's advanced healthcare directive. I'm not going to discuss grammar here. I take objection grammatically to that, but typically the closest family member decides. What's the closest family member? Spouse, kids, parent, grandkids, grandparents, whatever it is. It's not going to be the life partner, right? That person's just aced out. So Andy and Betty, they're life partners, not married. Andy's in a car accident and he's in the hospital. Betty has no right to access Andy's medical information, has no right to see him, has no right to make any healthcare decisions if Andy's totally out of it, no independent rights to see people. And these healthcare decisions will be made by Andy's closest relative, in this case, Charlie, and not Betty. So they're going to ask Charlie, what does Andy want? They're not going to ask Betty. So an advanced healthcare directive, as I said, that comes by other names: personal directive, advanced decision. This is a legal document empowering another person to make medical decisions. This is not a medical order like a POLST, which is a physician's order regarding life-sustaining treatment. That's a separate document, and that's something that is a medical order. So, if I'm in a nursing home and I'm sort of at the end of my life, and I say, look, if I have a heart attack, don't revive me, they're not going to resuscitate me. That's not a decision that an agent would make, but that's a medical order to do or not to do. And that's that pink paper in California. It's kind of kind of printed on cardboard. You might be familiar with that. You specify who makes decisions. So what do you do in an advanced healthcare directive? So in this case, Andy says, hey, I want Betty, not Charlie. I want Betty to make healthcare decisions for myself. And really the question is, do you want the plug pulled if you're a goner or not? It's up to you. You get to decide. And these are not easy decisions for many people. And it's typically activated when you can't make decisions because of illness or incapacity. I would also say consider pre-need planning. So another thing is, when a person passes away, who decides where the body goes? Who decides that this person's buried, cremated, whatever happens? That is going to be the agent under the advanced healthcare directive. And if you don't have an advanced healthcare directive, it's going to be Charlie, not Betty, right? So this goes back to the Andy situation where Andy's with Betty and then Andy passes away. Well, Betty has no legal position at all by statute because she's not married, unless Andy goes out and designates Betty to make these decisions, which you can do post-mortem, then Betty's just cut out. If Andy is concerned that there'll be a lot of drama after Andy dies, pre-need planning is where you go to a funeral home and you say, look, I want the blue casket and the red flowers or whatever it is in the cake. You buy everything, they give you a laundry list, you write a check, and that money goes to an insurance company so that when you die, whoever the funeral home is, when they deal with your remains, they make that claim and they get paid for those services. So what if you have an advanced healthcare directive? So let's say Andy and Betty are life partners. Again, Andy's in the car accident. And because Andy created an advanced healthcare directive, that's the acronym AHCD, Betty has full rights to access Andy's medical information and make Andy's healthcare decisions. Charlie is out of the loop. He's cut out. So you can see if you have a life partner, these are the documents, and we'll have a list for you at the end. But advanced healthcare directive, that's the one I lead with, because you know what? That's frankly the most important one, because Andy in this case does not want Charlie making healthcare decisions. He wants Betty to make those. So Andy needs to go out and do something. He needs to do an advanced healthcare directive. By the way, you can get this from a lawyer. You can download it for free off the internet. There's plenty of them out there. This is something that, obviously when a client comes to our firm, we're going to prepare a customized version, but these are kind of freely available online and they're by statute. So this is a statutory advanced healthcare directive. It's very important that once Andy says Betty is doing for Andy, the family has no say in things. Well, let's turn to finances. Finances, we'll ask it. We have several questions here. We'll get to some of these here right now. So question is there a time frame for the common law partner before they're considered spouse? Anita, thank you for asking that. I believe only Montana recognizes common law marriage. There is no common law marriage in California. And in most states, I believe Montana is the only state. So there's no common law marriage. Does an advanced healthcare directive, Jerry asked, does an advanced healthcare directive legal if it's filed in one state and decisions need to be made in another state? Yeah, Jerry, I think these, there's a less formal advanced healthcare directive. Basically, the hospital wants to know who's going to make the decision. So if you do a California advanced healthcare directive and you're in Vegas and slip on a banana peel and go to the hospital, right? They're probably going to honor that advanced healthcare directive. I could certainly craft a case where they wouldn't, but if you're going to spend a substantial amount of time in another jurisdiction, if you live part-time in California, part-time in Nevada, then you would want to also have a Nevada advanced directive for when you're in Nevada. And Anita, who's Charlie in the example? Charlie's the brother. So we have Andy, Betty, and Charlie. Charlie is Andy's brother. So financial decision-making, what if you don't have a living trust or durable power of attorney? What if you don't have these things? Because these are the two documents that we really look to. These are kind of the go-to documents for financial decision-making. And the reason there are two is because they address different situations. So a living trust is going to address what's inside of the living trust. You can think of that as a bucket that you put your house and your savings account and your stocks and your bonds and your mutual funds. And then your durable power of attorney for property deals with things that are not in your living trust, like IRAs, 401ks, annuities, and life insurance. So you do need both. They're kind of a little twin that go together. So if you don't have planning and Andy gets in this car accident, Betty's going to have to go through a conservatorship. And you know what? Charlie very well may be appointed as Andy's conservator. So it's a guardianship for an adult in California. So without planning, this is really important to understand. Betty has no say. So really, Betty has no more standing. And standing is a legal word that we use, or legal term that we use for an ability to go to court and complain about something or to want something done. You have to have standing. So you have to have the right to assert rights. Okay. Betty is kind of no one, because life partners aren't recognized by statute. They're not recognized by law in the sense that we're talking about here. So really, it's going to be Charlie, Andy's brother, making those decisions. So what can Andy do? Well, Andy can do a living trust. And again, this is a bucket you put almost everything into except IRAs, 401ks, life insurance, and annuities. A durable power of attorney handles those. And a durable power of attorney is a very broad document. And this is something you need to understand. Living trusts are legally far more narrow than a durable power of attorney. Now, a durable power of attorney may be 2 pages. I mean, it could be 25 pages. You might have a living trust that's 10 pages or 100 pages. So it's much longer. But I would argue that the durable power of attorney, because it's based on agency authority, and this is where Andy designates Betty as Andy's agent so that Betty can bind the principal, BIND, can bind the principal. What that means is Andy says, Betty, I'm giving you power of attorney to make decisions on my behalf. Depending on what the document says, if it's a broad document, Betty can do all sorts of things, way more things than Betty could do as trustee of Andy's living trust. So it's very important to understand, very important document. And these are things that a power of attorney can be effective immediately or upon disability or later, in the sense of you can activate it later. Most durable powers of attorney between married people are typically activated immediately. Life partners, it's case by case. So sometimes there are reasons why people don't want to get married. You know, one might have really bad credit, one might really have a lot of creditors, and so getting married can complicate things. So we just want to be careful with that and pay some extra attention to that. So what if you have a living trust and durable power of attorney? What happens? Well, Andy and Betty, again, life partners. Andy's in the car accident. Andy's in the hospital. Because Andy created a living trust and durable power of attorney, naming Betty in charge of everything, Betty has full rights to handle Andy's property, including real estate, banking, investments, IRAs, and insurance. Charlie, Andy's brother, has no say. So if Andy doesn't do anything, Charlie is the one who goes to court, and Charlie's the one who's kind of deciding for Andy. But Andy does have the power to do a living trust and a durable power of attorney, and really kind of cut Andy's family out from any say, or he can include the family. I mean, it just depends on the situation. But the point I'm making here, and something you need to understand, is that being married changes the legal status of the couple. Being life partners is less than marriage. It is not equal to marriage. And there's a lot of stuff that's not in there that you don't get essentially for free being married. Okay. Let's talk about property rights. An unmarried individual has no right to property that is not in his or her partner's name, right? So an unmarried, well, I think I might need to edit this. An unmarried individual has no right to property that's in someone else's name, right? If it's your life partner. In the event of a breakup, the property goes to the individual who retains the legal ownership. So Andy buys Greenacre and Betty lives with Andy for 20 years. The relationship ends and Andy keeps Greenacre and Betty owns nothing. That's what happens, right? But if Andy and Betty are on title, then Betty has an ownership interest that derives from being on title, not from being Andy's partner for 20 years. So again, Andy and Betty lived together for a long time. They split up. Betty's not going to get any of Andy's property. But if Betty happens to be on title, then she will get, based upon the fact of being on title, not the fact of the relationship. And that's different than marriage, because you can be married and acquire rights to property. So let me answer some questions here. Let's see. Thank you. There are some common law states other than California that allow, or some states that allow common law marriage. Kelly asks, is it best to have a living will or advanced healthcare directive, or should you have both? Yeah, Kelly, great question. The advanced healthcare directive says who makes medical decisions for you. There is a separate document called a living will that you can write that says, if I'm a goner, pull the plug. It's basically what a living will says. Those can be combined into one document. So it just depends on whether you want them into one document or separate documents. So Anita says, I'm not clear. Do people have to live together a certain amount of time before the party has rights? No, Anita, if you live together, you don't have any rights, right? If you're not married, you don't have the rights that married people have. So, and in California, there is no common law marriage. So there's nothing. Anonymous says, in Andy and Betty's situation, having a living trust does not automatically give Betty the power to make decisions unless Betty is named as trustee. That's absolutely correct. So just because, I mean, Andy could certainly name a trust that names Charlie as trustee. He absolutely can. If the IRA has designated beneficiary, can the durable power of attorney trump designation if there's a conflict? That's if the durable, so again, Anonymous, great question. This is if the durable power of attorney grants authority to change beneficiary designation. So Andy certainly could sign a power of attorney that grants to Betty. I'm not saying he should or shouldn't, but he could, in his durable power of attorney, give Betty the right to change beneficiaries. In a 401, if a 401k has a beneficiary naming the partner, wouldn't it go directly to that person? Yes, Anthony, that's correct. And we're going to cover inheritance rights in just a couple of slides. So debt, this is a common question. The individuals listed on the paperwork, right? Whoever signs the application for a credit card or the debt instrument, they remain responsible for the payment. So Andy gets an Amex Platinum, runs up $100,000 on it. Betty's not responsible for this debt. If Betty and Andy were married, Betty would be responsible for the debt to the extent of the community property, and Andy would be responsible to the extent of his separate property, but Betty would be on the hook. So when you're weighing, should we get married, should we not get married? If debt factors into it. That's something you're really going to want to pay a lot of attention to and figure out, if I marry this person, is this debt coming with them? And what does that look like? But if Betty, Andy takes out the Amex Platinum and Betty's a signer on the account or an authorized user, that certainly can change things. And I'm not going to tell you whether she's responsible or not, because it probably depends, because that's what lawyers always say. But that's something to think about. So if Andy has a credit card and Betty has a credit card, and separate accounts, that's probably better as a couple than if Andy adds Betty to the credit card. So what happens in inheritance if there's no will or no trust? This is called intestacy without a will. And after the Norman invasion in 1066, English law added the Germanic word and the French word. So you will see cease and desist. You will see last will and testament. Those are the Germanic and French words. That's why we say last will and testament, because one is German and one is French origin. So intestate is from Latin without a will, without a testate, right? Without a testament, a last will and testament. That's what that word testate means. But if a married person dies intestate, the surviving spouse, this is if you have no will and you're married. And the reason I'm mentioning people who are married is I want to contrast this so you can have a reference point. People who are married and there is no will, the surviving spouse takes all of the community property, 100% of the community property, and then separate property. So all property acquired during marriage is community property. All property acquired by gift or inheritance is separate property. That's treated differently. So again, the $64,000 question is, what's community, what's separate? There are volumes written on this. This is a source of intense litigation, the family law setting, in the estate setting. So this is a robust and well litigated area of the law, because as you can see, it's so important. If the deceased spouse, so there's the deceased spouse is the one who's below ground, that's buried. That is the dead spouse. The surviving spouse is the one who's alive, who's above ground. The entirety of the deceased spouse's separate property, if the deceased spouse doesn't have any family, no descendants, no parents, no brothers and sisters, no children of brothers and sisters, then the surviving spouse gets all of the deceased spouse's separate property. But if that deceased spouse has one kid, the surviving spouse gets half. And if the deceased spouse has more than one kid, the surviving spouse gets a third. So it depends. Again, like I said, lawyers say it depends. Well, what do you get if you're married and you die without a will? Well, it depends. What's your family situation like? So let's look at Andy and Betty. Andy and Betty. So we'll kind of load up. Andy has all the assets in this example, not because I'm picking anyone over any other. It's just A comes before B. Andy owns the home and it's in his name. Andy owns the bank account and it's in his name. Andy's IRA has a beneficiary designation, and Andy never created a will. And Andy's brother Charlie's going to inherit everything. Betty gets no part of the home or the bank account, and Andy's home is reassessed. So these are the three questions that we look at as a lawyer. When somebody dies, we ask three questions. What are the title to all the assets? Are there any beneficiary designations? And is there a will or a trust? And it's important to understand life partners have no inheritance rights whatsoever, period, none. Get your affairs in order, folks. If you have a life partner and you have outdated planning or you have no planning, this is where you really need to step it up and you need to go out and do something, okay? I'm not telling you what to do, but I'm saying, you need to start that process. Because again, the lawyer is going to look at title to each asset, the beneficiary, is there a beneficiary designation? So title to each asset, you can have property as joint tenants. Well, if it's joint tenants, Betty is, as the survivor, gets the house. And then you look at the beneficiary designation. If that IRA names Betty as a beneficiary, that IRA goes to Betty. So really the only thing we have left in the estate that is subject to distribution under the will or the trust is the $200,000, right? So in this case, Andy dies, leaving his life partner, Betty. And so what happens? So what can Betty do? Betty drags Andy into the lawyer's office. Andy creates a revocable trust. Andy keeps Betty as the beneficiary of the IRA. And Andy transfers title of the home to the living trust as well as the bank account. And when Andy dies, Betty does inherit everything. Charlie, the brother, gets nothing because, again, if Andy doesn't do this, Charlie gets everything, right? So Andy does need to go out and do a will or a living trust. But the home is reassessed, okay? So that's really important because if Andy's been living in the home forever and Betty's been living in the home forever, and their taxes might go up $10,000 or $20,000 a year, what can you do? So this is really important. So for those of you who are not married, or if you have kids, because this also applies to kids, this co-tenancy exclusion, a very little known Prop 13 exclusion, is really cool. So Andy and Betty are life partners, but only Andy's name is on the deed to the house. So when Andy and Betty come into our office, I go through this, and Andy and Betty say, look, we don't want the property reassessed when Andy dies. Let's say we know Andy's going to die first. We know Betty's going to be the survivor, but we don't want the property reassessed. So there's this co-tenancy exclusion since January 1 of 2013. If two people are on title to their primary residence, so this has to be a residence, and on the death of one co-tenant, the other co-tenant, the other co-owner of the property, we're not talking like rentals, right? With co-tenancy, this is a legal term meaning owner. The other co-tenant, the other co-owner is not reassessed, provided the transfer happens at death. So there's a lot in there, a lot that you have to do. No more than two people. They both have to live there as their residence, primary residence. They both have to be on title. And then that transfer has to happen by death. It can't happen inter vivos or between living people. So here's what Andy could do. Andy could transfer the property from Andy to Andy and Betty as joint tenants. That is not considered a change in ownership. That is not a reassessable event under California law. There's a reasoning why. I think it's fuzzy logic, but I'm going with it because that's a rule. Andy, as long as Andy stays on as a joint tenant and adds, so Andy conveys Greenacre to Andy and Betty as joint tenants, but Betty owns half the property. And that's really the problem with that, right? Betty now owns half that property. So is there another way? Because Andy's like, I love Betty, but you never know. And I don't want to put her on title. So there is another way. Andy can transfer a 1% ownership interest to Betty. So 1% of the property gets reassessed, but it's not going to raise the taxes that much. Now Betty's on title. Andy's living trust is on title for 99% and leaves the property to Betty when Andy dies. Betty is not reassessed. So that is one workaround. I know I went through that kind of fast. I get that. But understand that the point I'm trying to make here is there are a lot of gotchas that you're probably not aware of. And you really need to sit down with a savvy expert lawyer who knows what they're doing and walk through, because a lawyer's job is to kind of see into the future of all the possibilities and craft a plan that minimizes taxes, that minimizes legal fees, quite frankly, and minimizes hassle, minimizes just difficulties that are avoidable, right? Some of these aren't avoidable, and the lawyer's duty is to tell the client, look, this is going to happen. There's really nothing you can do about it, or you can do other things to help, right? So let's answer a few questions. We got a few questions here. So, what if the living trust is on the title? Yeah, that's fine. Jen, I think you asked that question. So the living trust could be on title, but that would be that 1% sort of, you could do 50-50, but 50% of the property would be reassessed. I get the feeling that this is all directed to, Anita asks, I get the feeling that this is all directed to benefit the live-in partner. Can you discuss what other person should do to protect what they had prior to living together so his assets stay with them and his or her children? Yeah, really, it's the same thing, Anita. Sometimes people benefit the partner. Sometimes people say, look, and you're going to see here, we have an example. If you have two wealthy people coming together and one spouse dies, the other partner or the life partner may say, look, I don't want any of that. Well, then that person just does their estate plan. And so it goes to that partner's family. So we got another question here. Is there a title transfer? Can the bank come back and call the loan? Interesting. Anthony, that's a very good question. So you do have to watch your due on sale clause. And that's something you would want to check with the bank in advance. Most people, so let's talk about taxes, death taxes. We're going to talk about death taxes. We're also going to talk about not only federal death taxes, but state death taxes. So for most people, except if you're a non-resident alien, so this is like somebody who is not American and lives outside of America, but owns property in the United States, they get a $60,000 exemption, 60,000, a little tiny exemption. But most everyone else gets a $12 million death tax exemption, which is a coupon. Basically, if I have a $12 million estate and I die, I can leave to whomever I want and no taxes. I can leave an unlimited amount to a spouse, no taxes. You could be have $100 billion in wealth and leave it to your spouse, no death tax, because there's something called the unlimited marital deduction. If you're a life partner, guess what? You don't have that because you're not married, right? And then amounts over 12 million are subject to a 40% estate tax. Now you hear the term death tax, which can be viewed as a political term. We use that to cover both the state and federal estate tax. So when you hear the term estate tax, typically people are saying federal only, and that's 40%. It used to be 55. In the early 70s, it was 77%. So that number goes up and it goes down. It's up, it goes down. Don't forget state death taxes. State inheritance taxes, death taxes can be 20%, and that starts much lower, and we have a few slides on that. So it's something really to pay attention to. So if you're in California, you're like, okay, we're going to sell our house, we're going to move to Washington. Washington has one of the biggest death taxes in the whole country, okay? You really need to know what you're getting into. Some states are great to live in, not so good to die in. California's a great state to die in, okay, because you get a lot of tax benefits. But other states, not so good to die a resident of that state. So you don't file with taxes. If you're a registered domestic partner in California, you can file jointly on your state income tax. That's just something to be aware of. So that is that. And we're not covering registered domestic partners. Again, that term is interchangeable with the term spouse under California law. So we'll cover that question in just a little bit. Let's say taxes. Andy and Betty each have a net worth of 12 million for a total of 24 million. Andy creates a trust and leaves everything to Betty. When Andy dies, Betty now inherits Andy's estate. She has 24 million, no death tax because the current exemption's $12 million. But when Betty dies, $4.8 million in tax, right? Andy says, look, I'm just going to give it to you, Betty. I don't know who to give it to. I don't have anyone. I've got you. I'm going to leave everything to you. So now Betty's got 24 million, $5 million in tax. So instead of just leaving it to Betty, right? And I would say most living trusts I look at, because we look at a lot of living trusts in our firm, most of the ones that we see, it says, when Andy dies, the trustee shall distribute to Betty the entire trust, whatever's in there, once everything, the 6 or 8 months it takes to administer a trust, because there's a lot of stuff you have to do when someone dies. Give Betty a check for $12 million. Great. You've avoided probate. Betty's gotten the 12 million. Well, now Betty has a death tax problem, right? So instead of distributing the 12 million directly to Betty, instead of giving Betty the check and causing a $4.8 million tax bill in Betty's estate, Andy's living trust has language that sets aside a special trust for Betty. Betty's in control of that trust. She gets as much money as she wants. And when Betty dies, that money passes outside of the estate, maybe the way that Betty wants, maybe the way that Andy wants. There's broad flexibility, but the point here is you do need to pay attention to dollar amounts, because dollar amounts matter when it comes to taxes. Also bear in mind, January 1, 2026, that $12 million number adjusted for inflation, so it'll be bigger, adjusted for inflation, that $12 million number is going to be cut in half to $6 million. Okay, so in 2011, we got a $5 million exemption with an inflation adjuster. In 2017, we got another $5 million exemption with an inflation adjuster, but that 2017 extra $5 million goes away at the end of 2025. If you have an estate greater than 10 million, if you're married, you've got maybe more than 15 million, I don't know, whatever the number is. But if you're over 10 million and you want to do some advanced planning, we have a lot of content on our webinar on this. What do people do who have money to do tax planning? And I kind of go over some of the planning strategies. You need to get on it quickly on this, because I'm telling you, I talk to other lawyers. Lawyers all talk, right? I talk to other trust and estate lawyers. They're all getting really busy. And a lot of people are stopping taking clients for this year right about now. Now, it's not our firm, but a lot of people, they're just small shops and they just can't handle the volume. So they stop taking clients. Well, it's only going to get worse as we get closer to 2026. So there is a way that, and this is a fairly innocuous way for Andy to set up some very basic planning for Betty. So we have a few questions here. Anonymous asks, if the parents live in one state and the kids live in another state, how are the estate taxes calculated? When the adult kid moves to another state, do they need health directive in the state that they're moving to? Anonymous, yeah. So I think if you're living in a state, you should check in with a lawyer who's licensed in that state and get all the appropriate documents, healthcare documents, powers of attorney, whatever it is. Living trust, kind of technically, you can go to any state. I mean, you could be in California and choose Delaware as a state to to write your living trust under. Most people don't do that. They write it under the state that they're a resident of for a lot of reasons. But I would say certainly check in with a lawyer licensed in that state. And then if a kid moves between states, the federal death tax is national. But then there are these other state taxes. Some states, as you can see, do have an inheritance tax: New Jersey, Pennsylvania, Maryland, and it's just Maryland has a death tax and an inheritance tax. Pennsylvania has an inheritance tax, and so does New Jersey. So, and we'll cover what those amounts are. Let's see. Gene says, what is the name of the special trust for Betty? Oh, yeah, Gene, it's a general needs trust. So what we do for Betty is we would set up a generation skipping trust. And because Gene's a lawyer. And thanks for the question, Gene. We would set up a trust that is a general needs trust, which is a term in the law that we say it's not special needs people for loved ones. It's a trust for loved ones with special needs to protect government benefits. It's a general needs trust with generation skipping provisions. So it's a generation skipping trust. And then you give you give Betty a limited power of appointment so that it's not included in her gross estate at death. And then she can leave that to whomever she wants, or not, or Andy cannot put that in there. So, all right. So you can see, look at California, folks. For those of you in California, can you believe it? There's no estate tax. There's no extra inheritance tax. I told you California is a great place to die for a lot of other reasons too. But Washington, not so much. And what I've done is I'm not going to read all of these, don't worry, but you can see these are not small numbers. 10%, 11, 20% Hawaii. So that's the amount of tax you pay. And the next question is, well, when do you pay that? How big does the estate have to be to pay that? Well, you can see it's different, right? I mean, DC's 4 million. 4 million, it's not that much. 4 million in Illinois. Now, something also to understand is you may say, well, Jim, I don't have to worry about that. I'm a California resident. You said it's great to die in California. I've got a vacation home in Brookings, Oregon, which is in the banana belt. Believe it or not, there is a banana belt in Oregon. Beautiful town, Brookings. Look at that. 16% on estates over $1 million. And I can tell you what Oregon does, and I suspect probably every other state does. Oregon counts all of your assets everywhere, and they put the Oregon property on top. So if you have $1 million estate and you have a $500,000 Brookings home, they're probably $1 million now, you're going to pay tax because they're going to say, oh, we're going to count all those California assets and we're going to put the Oregon asset on top. So when this is not $1 million of property located in Oregon, this is $1 million estate, and they look at your other assets. So very important. If you move states, you really need to pay attention to this if you care about it. Now, some people just don't care. And then Washington is the biggie. I think Washington, this is for people. A lot of people move to Washington to avoid income tax. But remember, they're going to zing you on capital gains tax. I believe it's over $250. There's a tax. They also zing you on the death tax, and that's an extra 20% on top of the federal. So you could be in a situation where you don't have any federal death tax, but you do have state death tax. So it's something really to be mindful of. And Anthony asks, if I'm a California resident, but happen to die in another state, am I stuck with taxes where I died, even without assets in the other state? No, Anthony, if you're visiting, if you go to Washington to, cruise the San Juan Islands and you get hit by a beer truck or something, no, you're not. It's where you're a resident of or properties located in. So you would not, Washington has no authority to impose a death tax because you took a vacation. Anonymous asks, in the Oregon example, the taxes from Oregon will be on the total estate of 1 million. It is 16% of tangible assets, which is real estate, tangible assets located within the state of Oregon. Okay. So tangible assets include real estate. They also include deposits in a state chartered bank. So you really need to watch, literally the chartering of your bank. It gets that granular. So this is where you need, if you have property in some of these jurisdictions, you really need to talk to somebody who's knowledgeable, because I will tell you, I'm going to tell you a secret, and don't tell anyone. A lot of estate planning attorneys don't know this stuff. They just don't, because it's not taught. Well, I'm deciding who gets what, and I'm deciding, I want to avoid probate. Well, it's great who gets what, but the next level is, what are they getting net of tax? And, it's not what you make, it's what you keep. It's not really what you're transferring in your estate plan. It's what the people are actually getting, because the government oftentimes takes a rake that can be avoided. For example, if you have commercial property in Oregon, here's a workaround. This does not work with a personal use asset. You can transfer that property to an LLC. That becomes an intangible. And if you're not an Oregon resident, you bypass the Oregon inheritance tax. So this is very, very important. You need to work with lawyers who know what they're doing. So punch list, this is kind of like not boring like black letter law. This is stories. Like, you can't take it with you. The Vikings tried it, and they'd send a ship out on fire, the Viking funeral. But it's very important. You can't take it with you, so it's going to stay behind. And what we do is we tell a lot of stories to prompt you to think about all the things that I know the estate attorney is going to ask you. And I got to tell you, if you're not ready for this, you're going to go, well, I don't know. Let me think about it. I don't know who's going to make healthcare decisions for me. Gee, if my kids don't survive me, who gets it? I don't know. And what I'm doing is I'm prompting you in the book to just at least think about this and put some mental effort before you go to the lawyer's office. So buy the book, and again, find an experienced lawyer knowledgeable about Prop 13. If you're in California and you own real property, you have to get someone who's knowledgeable in Prop 13. Prop 13 is California's property tax system. It's arcane, it's medieval, it's weird, it's grossly unfair. A lot of people think it's grossly unfair, and the people who are benefiting from it see no other option, because you can't, a lot of people say I couldn't possibly afford the property taxes if it was assessed, if I were paying 1% of fair market value. So I'm not going to get into whether Prop 13 is good or bad. All I'm saying is, if you've owned property for any length of time, you're going to want to pay attention to this, because I will tell you, I see it all the time. Lawyers give bad advice and clients end up getting reassessed. And it's just too bad. So finding a lawyer experienced in Prop 13, consider use of the following documents. So a revocable trust, and then I also put a will. So if you own real property in California, you're probably going to need a living trust. And when you do a living trust, you also need a will that leaves everything to the trust, right? Because a will doesn't cover necessarily everything. And really everyone should have a will. Like, even somebody with no assets should have a will, because you need to figure out what to do with the little stuff that you have, right? You might have 5,000 in a bank account. Well, it's got to go somewhere, right? A durable power of attorney for property management and personal affairs. The durable power of attorney can be, that comes in a lot of different forms in our office. We custom tailor the statutory. There's a uniform statutory form power of attorney. There's a statutory form power of attorney. There's an attorney drafted power of attorney. There are a lot of variants on that. And then the Advanced Healthcare Directive and HIPAA authorization. I didn't mention that, but a HIPAA authorization basically gives other people access to your medical records, even if you're not incapacitated. And so, if you get a surgery and you need someone to go, talk to a doctor, you need to give permission either in advance to that physician. When you go in to have a procedure, they'll say, well, who do you want us to call? That's giving them permission to share medical information. If you don't have that, if you get in a car accident, you don't have it because you haven't been able to fill out anything. That HIPAA authorization is a permission slip where people can go ahead and talk to your healthcare provider. So very, very important to consider. Really get an A-team on this. And a lot of this is, and I use that, the analogy I'm using is from the 80s. But, the A-team in my field is really the lawyer, CPA, financial advisor. That's really the three-legged stool. And the three of them need to work together, right? They can't just be working in isolation, because this stuff is frankly way too important. And that brings us to the end. And go ahead and check out our YouTube page. I really would encourage you to subscribe to it and hit the subscribe button. And our YouTube content comes out every Thursday, four Thursdays a month, I'll put it that way. And it's great information. So I know we've covered a lot of things. We take a deep dive into like, what is a living trust? And that's all covered in the videos there. And if you'd like to make an appointment, schedule a time to talk. We do offer a free 15-minute call. So you can talk to somebody before making an appointment to see if it's a right fit, if it makes sense. But you can go ahead and schedule a call by going to our website. And again, subscribe to our YouTube channel, and please review us on Google. In this day and age, we love great reviews on Google. So you can just Google our name and it will literally pop up. So I will take in our last few minutes here, I'll take some questions. If you have any questions, now would be the time to put them into the Q&A. So Anonymous asks, do you pay estate taxes in 2 states if you live in 2 states? Yeah, I think if you're going to have residency in one state or the other, but it's possible you could, it's if you live in 2 states or have property in 2 states, that's something you're just going to have to figure out. But typically people live in one state and not the other. And typically it's where you spend more than 6 months, like 6 months in a day. I leave it up to you. And that's something to talk to your CPA and lawyer about on a sort of a case-by-case basis. What is the effective date that Prop 13 made the change, or is it coming and when? Yeah, Prop 13, this parent-to-child reassessment exclusion is basically gone. We're having to rely on a bunch of other approaches, quite frankly. And there are other approaches. They're just, frankly, they take longer to implement, years. And frankly, they're just more money. So more attorney's fees, unfortunately. The POLST. So on the Advanced Healthcare Directive and the HIPAA, the POLST is a medical order. And a POLST says, if I'm choking on a peanut, don't give me, resuscitation. That's typically for people who are in palliative care toward the end of their life, are very aged people. That is not something that I recommend that people consider having unless prompted by a medical professional to consider having it. So it's not one of those kind of normal documents that people have. The POLST is if you're in this certain situation. And typically what happens is the medical providers will prompt you and they'll say, look, if this person falls down or if they're, will relieve pain, but, should we cart them off to surgery if they're 95 years old and they fall and break their hip? A POLST would say, no, don't take me to surgery. And that's the medical order component. So there aren't any other questions. I want to thank you. This will be posted on YouTube and we will see you next time.